All right, if I may, please take your seats.
You should probably both introduce ourselves.
We're now going to hear from our panel on international arbitration.
Thank you very much.
I mean, if we're still gonna ask you, like, we're just.
Yeah, it's an angle.
All right, thank you. I'm not going to spend time on introductions. I will turn this over to our co-moderators, Bernardo Cremades and Victoria Sahani. Thank you.
Good morning to everybody. When we plan to organize this meeting about emerging trends in third-party funding, we thought it was very important to speak about international arbitration. And that's the reason why we organized with Victoria and myself this panel, fantastic panel, to talk about international arbitration. We plan to have 4 speakers. One is Jeff Commission, he's the director from Mulford Capital, and Nargis Torres, founder and CEO of Lex Finance. So we wanted to start listening to the financial point of view in international arbitration. And then we want to hear 2 arbitrators, Dana McGraw and Ruth Teitelbaum. So I think let's start without any introduction because everybody knows very well. I just wanted to introduce Victoria Sahani, who is co-moderating my co-moderator of this panel. She is at the Boston University, recently appointed over there, and we are looking forward very much listening to the panel. Please, Jeff, the floor is yours.
Thank you, Bernardo, for your kind introduction. First, let me just shift gears. So we spent the morning and it was a very illuminating panel, but this one is going to be a bit different. So we're now moving into the world of international arbitration. So what do I mean by international arbitration? Well, it can really be broken down into 2 kinds of arbitrations. One is very much like commercial litigation. It's 2 sophisticated corporates who agreed, instead of going to the Southern District, to ICC arbitration or AAA arbitration. So you have what is characterized, and accurately so, as international commercial arbitration. So that is, oh yeah, so that is segment 1. Segment 2 is investor state arbitration. And those are disputes between foreign investors and countries and sovereigns, so to speak. So we have those 2 kinds of disputes, and that's really what we're going to focus on here today. Now, I really just have 3 points to make, and I'll move methodically through each. But the first is third-party funding in arbitration is very much now in the mainstream. So why do I say that? I say that because third-party funding in arbitration has been going on for more than 10 years. You can now empirically look at a variety of data points that show that. So I brought with me, and you have to buy these now from ICSID. ICSID is the International Center for the Settlement of Investment Disputes. It's an arm of the World Bank. It administers more than 70% of all investor state arbitrations. There is now a rule for third-party funding that requires disclosure. And international arbitration is different than commercial litigation, and there are now rules, but by really the world's leading institutions that administer these cases, because arbitration does not involve judges, it involves arbitrators. It involves arbitrators like Bernardo and others who are active participants in the space. So they may be working as counsel, they may be working as experts, or what have you. So there is a rationale for entrenching this disclosure regime in investor state and international commercial arbitrations. But I referred to data points. So if you look at the most recent year for which data is available, there were 249 funded arbitrations in 2021. And we know that because the law firms that were involved in those arbitrations reported those figures to the leading publication in the arbitration space, Global Arbitration Review. So that's 249 funded cases that law firms reported. Secondly, increasingly in the last, I would say, probably 18 to 24 months, companies themselves are now reporting when they secure funding. And you'll see this, they do so either because of a listing requirement or because they felt that is prudent to do so. But in the last, I would say 12 months, there have been at least a dozen companies that have reported, many in the extractive industry sector, that announce the fact that they've secured funding. They oftentimes will not mention the funder, but they will announce the size of the facility, and they'll reference the dispute for which the funding was secured. So you have counsel acknowledging the fact that they're working on funded cases, 249 in 2021. You have companies that are making public announcements of the fact that they've secured funding. And then third, you have the fact of funding that it's now being recorded in decisions. So you have decisions of arbitral tribunals that are recording the fact of funding. And it's not just single case funding, or it's not just portfolio funding. We are now seeing, because funding has gone on for some time in international arbitration, we are seeing monetizations being referenced in decisions of arbitral tribunals. So typically, I mean, any arbitral award, like any judgment, is an asset. And we are now seeing tribunals grappling with the fact that oftentimes post arbitration, so to speak, after the original arbitration proceeding has reached its natural conclusion, these awards are being bought and sold. And that's happening with increasing frequency with these awards, ICSID awards, so to speak, because they are enforceable around the world. And there are over 150 contracting states to the ICSID convention. So you have these three data points that really, quite frankly, establish that funding is now, it's in the rules of ICSID, it's in the rules of the ICC. The SEC doesn't have a rule, but it has a policy statement encouraging disclosure. And the only institution that hasn't adopted a rule is the LCIA, probably the second leading commercial arbitral institution to my mind. But they considered it, but they thought it wasn't necessary. It doesn't mean that funding doesn't occur in LCIA arbitrations, but they felt that it wasn't needed. So it really is in the mainstream. Secondly, what we're now seeing, and this is not a new development, but parties are now seeking, and in some cases recovering, the costs of funding. So it's not something that it's not something that's directly addressed in the rules, but there's now a series of decisions involving both ICC and ICSID awards, where parties, as part of their cost submission at the close of an arbitration, are including the cost of funding, and that could be the cost, the time spent on procuring funding. In some cases, it also includes the funding premium. So in many of these arbitrations, it's oftentimes a combination of a multiple and a percentage of award proceeds, and parties are now seeking that in their costs. And it's not new. I mean, there's a decision, an ICSID case from 2014 involving Turkmenistan that was funded. So we're going with 2014, and in that particular case, there was a contingency agreement with the European law firm, and it was a funded case. And in that case, the claimant sought the cost of funding. In that case, the tribunal declined to award those costs for three reasons. First, because it was introduced late into the proceeding. So Turkmenistan wasn't aware of the fact of funding until the very end when the cost submissions came. Secondly, the tribunal didn't find the cost of funding to be reasonable. And that is a requirement that I think is really the key benchmark, reasonableness, that tribunals are looking at. So there's no question that increasingly tribunals are finding that these costs are recoverable, but the question is, are they reasonable? And what are they comparing, or what is the test for reasonableness? Oftentimes it's, what is the funding premium in relation to the amount spent in terms of fees and costs? What is the funding premium in relation to the amount of damages awarded? Another consideration. But you have that 2014 decision against Turkmenistan. You have a more recent decision in 2019 involving Egypt. Again, that case involving an individual was one where the claimant sought the cost of funding. Again, the tribunal didn't award it, but they had no problem with the fact that technically they are recoverable. And finally, there's a more recent decision from 2020 involving Panama. Again, a Canadian mining company, sought the recovery of the cost of funding. In that case, the cost of funding were included in the premium about $32.5 million. The tribunal again didn't award them because they didn't find them to be reasonable. But that's in the investor state context. There are now at least 2 ICC decisions where tribunals have awarded the cost of funding for more modest amounts. And those amounts are more modest simply because ICC cases are shorter in duration and they cost less. So the funding premiums were single-digit millions. But there are at least 2 ICC awards which have been upheld by the UK courts where arbitrators have awarded the cost of funding. So it's something that I think we will see with increasing frequency. Finally, and this is the point on which I'll close, there's a fair bit of misinformation about the use and practice of third-party funding in international arbitration. And I say that because we participate in the ICSID rule revision, the process that resulted in this rule is a 5 to 6 year process. But at the same time that that's going on, there's another reform process for perhaps the second leading arbitral rules that are chosen for these disputes. And I say chosen, I mean that they're one of the options that investors can choose in a bilateral investment treaty. And those are the rules of UNCITRAL. So UNCITRAL Working Group 3, a UN organ, is in the process of reforming investor state dispute settlement. And there's probably 25 issues they're looking at. One of them is third-party funding. And in that process, there's a lot of misinformation. There's pure conjecture that there's increasingly frivolous claims are being funded, or that funding is inflating the value of damages claims. Unfortunately, and we've done this through ILFA and elsewhere, none of these assertions hold any water, because when you look at the empirical data, there are mechanisms to dismiss frivolous claims. For instance, at the leading institution, ICSID, they have a 41-5, it's like a summary dismissal mechanism, and there's been no uptick in decisions in funded cases that shows that there's an increase in frivolous cases. ICSID can also refuse to register a case. There's not been an uptick there either. And similarly, there has been no evidence to support this idea that that damages figures are being inflated or what have you. So that's a reform process that is nowhere near its conclusion, and they're dealing with much more than just third-party funding. But it's something that is on the horizon in the next couple of years. I'm hopeful that they'll end up somewhere with a rule that is like this one, that only requires the disclosure of the fact of funding. And the reason for that is to avoid any conflict of interest. And I think I will stop there to afford ample time to others.
Thank you, Jeff. I think it was very interesting to listen to you, because normally in those meetings when we speak about third-party funding, normally people speak just about litigation, not about arbitration. That's the reason why it's very important to put the arbitration on the table when we speak about third-party funding. Arbitration is not very well known. Yesterday, arriving to New York at the immigration, the officer asked me, "What are you coming for?" I say, "Well, I'm coming for a meeting with arbitrators." I say, "What's that?" "Well, I am a lawyer." "What kind of law do you practice?" I say, "I practice international business law and I do some arbitration." He looked to me and say, "Guy, you must make a lot of money." That was the only thing he understood about that. Now, let's talk. Nargis, I think you have the floor now. Nargis, it's a real expert in third-party funding in international arbitration. And he will talk about something which is very interesting, is the secondary market on arbitration. And please, you have.
Thank you, Bernardo. First, thank you very much to the NYU and the organizers of this conference for inviting me. It's always a pleasure to discuss these topics in an academic environment, which is always challenging, but a treat. So let's go to the point. Basically, what I want to share with you is our experience from the Ibero-American market and from civil law countries, how we do things regarding international arbitration and financing international arbitration. There are like 7 ideas that I want to present to you. The first one is something that already Jeffrey mentioned, the total acceptance of seeing the International Arbitration Award as a financial asset, and as a financial asset could be monetized. Second, to understand that as similar in litigation, in arbitration, you deal with two risks: collection risk, the ability to collect the award, and also decision risk, that you get the right decision in favor of your client. The third element here is the emergence of the participation of new financial interests. I mean, family offices, high net worth individuals, foundations, institutional investors that discover that financing international arbitration could be more attractive or similar compelling than financing litigation in local courts. So in the Ibero-American market, and specifically in civil law countries, the development of the third-party funding has been more focused in international arbitration rather than litigation, because the size is bigger, and we don't have many barriers of entry that you guys have in the United States or in the common law system. Champerty, maintenance. We share usury laws that limit the type of interest or the type of compensation that you can get. But usually, the way that we have managed to overcome those barriers of entry has been connecting the arbitration market with the securities market. Because in that way, if you have a solid secondary market, the primary market, which is financing costs, will develop more easily. How we develop the secondary market? Mostly doing two things. First, monetizing international awards. I mean, put together a group of investors that share of interest in mining, environmental issues, corporate disputes, shareholder disputes, which is quite common, and set up a consortium and participate, putting together an amount of money in order to acquire, with a discount, arbitration awards. And then use the defining and most important tool to make this happen, the New York Convention. The New York Convention is an international convention that allows you to recognize and execute international awards, either in commercial or in investment arbitrations in another set, and try to collect the money in one of the more than 170 countries that are part of that convention. The United States is part of that convention, Spain is part of that convention, and all the Latin American countries, the majority of the civil law countries, are part of the convention. It's the most important tool. Without the New York Convention, the secondary market or the primary market for international arbitration or the funding of international arbitration wouldn't exist. That's in my opinion. So it's very important to understand that rule, which allows that this system exists. The other framework is the ICSID Convention, which allows, the set of rules if you begin a dispute between or among investors and states. So those are the two sets of rules that you have to understand in order to set up a strategy to monetize international awards. The other tool that has been very useful for the development of the secondary market for international arbitration have been, in our experience, especially in South America, is the monetization of settlements. I mean, sometimes, international arbitration allow you very complex disputes. And sometimes one party has to go to arbitration because they have not a solvency problem, but a liquidity problem. And when you have a liquidity problem, you have an opportunity for the participation of a funder to propose a formula that allows to one party to get probably a less amount than the claim amount, but the other party will assign your rights to the funder, and the funder could stay 2, 3, or 4 years. For example, it's very common for us to monetize earnouts, escrow accounts that are discussed in international arbitration disputes. Something that could be analyzed from the financial point of view and could be attractive for different set of participants. And that's the other characteristics in the Ibero-American market and civil law countries. Usually, the co-investments or the set of pools are different. Usually we don't like to raise one fund to invest in all the disputes. We prefer to set different type of common interest agreements among different type of investors according to their profile, and in order to avoid conflict of interest, which is very important for us. Nobody wants that your arbitration award is going to be annulled. That would be bad. And unfortunately, it doesn't happen, at least in our experience, when some funder has been involved since we started this business 9 years ago. So you have that, and with that is basically the secondary market. You can offer that a piece of this investment to family office or high net worth individuals, and they allows you to participate in the market. Or you can invite other funders to co-invest with you if the amount of money is bigger, or if you want to spread the risk. So I would say this is the special characteristics of the international arbitration market in the Ibero-American market. And I think I will stop there to allow my colleagues to comment and participate in the discussion. Thank you very much.
Thank you, Nargis. I think you will have a very difficult time to explain to a traditional lawyer who at the law faculty was studying with Champerty or other forms of considering the law. But anyhow, to admit that an arbitration claim, it's a financial asset, that's going to be quite a difficult thing. But anyhow, we'll talk about that in the discussion with afterwards, the question and answer. Let's move to Ruth Teitelbaum, who is an independent arbitrator and practitioner, and she is general editor of Arbitration International. Please, Ruth.
Thank you. I'm going to discuss investor-state arbitration and also the ICSID convention. And I just want to say briefly that I believe that ICSID is one of the most astounding, successful experiments in international law today. When one compares it to other international tribunals and organizations, look no further than the WTO to see what is now a totally dysfunctional appellate body, thanks to the US government in great part, a place where a small country like Antigua and Barbuda cannot enforce its judgment against the United States. For example, ICSID has 158 member countries, all of which recognize an award as the equivalent of the highest court of its own jurisdiction. And it's only 10 years older than I am. But I think it's an unfinished symphony, and I want to talk about that today. There is an increased backlash, however, a very heated backlash against investor-state arbitration, and so-called third-party funding, however you want to define it, is at the heart of this debate. I don't think it's just one part of the debate. I think it's actually at the heart of it. And I believe that the amendments to the ICSID Convention on disclosure, to the rules of ICSID on disclosure, are going to do very little to mitigate this heated backlash. And to understand why governments distrust funders is to understand, I think, the heart of the legitimacy, the so-called legitimacy debate in investment arbitration. It is not about transparency or a fear of the unknown. It is a fear of something familiar, which is sovereign debt litigation, a phenomenon that took off after the ICSID Convention came into force. And it started really in the 90s. It's where hedge funds or other investors, normally only those which have billions of assets under management, purchase sovereign debt at a distressed price when the country is in distress, with the idea of holding on to the debt and hanging on and not renegotiating the debt, and then suing the sovereign for a profit. And the lawsuit itself is a menace to the state, because just the presence of the litigation can prevent a state from issuing new debt, from exporting goods, etc. But if the presence of the lawsuit itself isn't enough, then the creditor of the sovereign debt can go after commercial assets of the sovereign in jurisdictions all over the world. Now, why is this even possible, the sovereign debt litigation? It's because of a gap that's being taken advantage of, that there is no international bankruptcy protection for governments. So unlike in commercial litigation, there are no court mandated stays of litigation, no creditor haircuts. So it's, I guess, the ultimate power trip that one can push a country to the brink by holding on to this sovereign debt. Now, this really took off in New York with the Elliott Associates case versus Peru. Peru had argued that this was a case of champerty, that actually the only reason for buying this, the purchase was made with the sole intent of litigation, that Elliott Associates knew that Peru would not be able to pay back the debt. The Second Circuit disagreed and said, well, no, there was a contingency here. Elliott Associates thought it might get paid back or it might sue. And that's the law now. Other circuits have followed suit. The New York legislature intervened and basically eliminated the defense of champerty for debt purchases of higher than $500,000. Now, is a hedge fund or any kind of private equity fund or any fund that finances an investor state arbitration, let's say an ICSID claim, is that the same as a sovereign debt purchaser? I think the answer is absolutely not, because the risk, as you've just heard, is entirely different, at least at the outset. There's a huge contingency risk. You might not win. You might not get paid, although most sovereigns pay eventually, and the word eventually is a topic for an entire day. But the hope is that you do get paid, not that you don't, not that the sovereign can't pay. So it's a completely reversed and mirror image, I guess. But what happens when an international arbitration award owed by a sovereign goes unpaid? And I mean, isn't paid in accordance with the ICSID Convention, not paid in accordance with the treaty, not paid right away. What happens then? Well, then what happens is that the investor, the claimant, the funder, all the creditors of this debt, those who purchased the award on the secondary market, they are sovereign debt litigators. That's what they are. That's what you have. You have a right to enforce that sovereign debt in courts all over the world. This is no longer the peaceful settlement of disputes of ICSID. This is really something else. And this is where third-party funding and sovereign debt litigation come and meet. It's the same party. Now, and this is what I'm going to call the money problem. The money problem, which is the unfinished symphony. So this is what the money problem has looked like so far in these disputes. So far, I'm going to take a small developing country, and just so you can stay with me on this, I have combined a Latin American country, an African country, and two little island states. And there's a reason I have done this, but it's going to take a while to get to my point. But this small developing island country has beaches, fishing, and offshore oil and gas. It enters into a concession with an EU-based energy company. There's a war in the Middle East. The price of oil skyrockets. So the state says, we're going to expropriate this, or we're going to reverse our commitments because there's just too much profit that we're not getting. And so there's an ICSID claim, let's say. And let's say that there's an award of $1 billion. And let's say this little country, the GDP is $4 billion, and it has debt. Now, this is a troubling scenario. But the logic, or what has been happening, the way this has been resolved is that, well, the country does have an oil and gas concession itself. It has nationalized it. It does have a revenue stream from which it can pay this foreign investor sooner or later through some type of settlement, maybe after sovereign debt litigation, maybe after the investor seizes a barge, maybe through a combination of cash and bonds. That's how these disputes, the money problem has been solved. But now we have a new money problem. So I'm going to take the same country. Same country today, it has oil and gas, beaches, and fishing. But now, today, it's been downgraded by sovereign credit rating agencies 3 times. So one time due to the pandemic, didn't have vaccines, it had no tourism, it had no fishing, and no one could work. One downgrade. It's downgraded again per the Montreal Pledge and the Paris Agreement on climate change because of its carbon footprint. And it's downgraded a 3rd time because it's an island and it's vulnerable to climate change. So it gets another down. Now, what is the effect of these downgrades? One must understand that it forces the state to borrow capital at much higher rates than it would have previously. It also owes US $8 billion to China with adjustable rates, which sounded like a good idea at one time, but now with inflation are a complete disaster. Now, let's talk about its fishing industry. You get why I have this combination. I want to tell you that 3 of the things in this hypothetical are happening to one state, just so you don't think this is totally crazy. And a few things are happening to 2 others. So it exports canned tuna to the EU, this little country. But now the EU has proposed a carbon border adjustment mechanism, which is a tax on carbon footprint leakage. So it doesn't want carbon to be leaking from this little country and competing with EU companies. So this tax is going to cost this little country 1% of its GDP. That's 40 million a year. Also, the IMF and certain EU countries, including Germany, have promised, not in writing, have promised this state that if it ceases its oil and gas activity, they will help this country restructure its debt. It will provide it debt relief assistance, which is a good timing since it owes $8 billion to China right now. But it has to cease its oil and gas activities, and it must invest in its coral reefs and biodiversity in exchange for this debt relief assistance. So the Ministry of Finance of this country does the math, sits down and looks at this and says, we need to terminate our oil and gas activity. And so it decides to expropriate this oil and gas concession. So now it owes $1 billion to the EU energy company. And it really doesn't know how it's going to pay for this because it doesn't have this revenue from the oil and gas because it didn't take it for itself. So it calls up the EU and says, you know, maybe EU, you could pay for this award. And the EU says, huh? We're the EU. We came up with this acronym, ISDS, for investor state dispute to make it sound like a disease, because we hate investor state arbitration. That's all we talk about. It's a bad word in the EU. We won't even pay our awards. We're going to pay your award? Oh, no. But you better figure out, little island country, how you're going to pay this EU company if you want EU companies to come back here and invest in your energy transition and put windmills out to sea. So do pay that award somehow, figure it out. So while this country is trying to figure this out, the investor initiates sovereign debt litigation, seizes an account in Luxembourg, which pertain to the coupon payments owed to China. So this country owes $8 billion to China, and it pays these bond payments through this account. And so the country defaults on its loan. Now, we know from the Asian financial crisis of the 90s that a sovereign debt crisis from one small country, in that case it was Thailand, can spread like wildfire and wreak havoc on the global economy. And I think what this hypothetical shows is that the money problem in investor state arbitration has always been a fragile wager that country will eventually be able to pay. And amazingly enough, most countries have eventually been able to pay. But I believe that this situation now presents a hazard to the global community that we cannot ignore. But I also believe it presents an opportunity to rethink the way these awards are paid altogether. And there's no reason why we could not consider ICSID, consider it as an international organization, it is, and finance it as a single tribunal that happens to be administered by many arbitrators. The WTO is financed this way. NATO is financed this way. And I think that the WTO collects over 200 million a year in annual dues. And this is, the United States doesn't even apparently believe in the WTO, and it submitted its check this past year for 20 million. Antigua and Barbuda, which has been completely buffeted by the system, submitted its little check of 29,000 Swiss francs last year. I believe these contributions could be made through actually sustainable bonds, so that they're actually investments in climate change at the same time as being a type of insurance against risk for these claims. And I have some hope that there is a sense of enlightened self-interest and burden sharing that is coming out of these COP27, the last meeting, because of that loss and damage fund. That is exactly the idea of that fund, that it is burden sharing. And it really is a question of whether wealthier countries will step up. Thank you.
Thank you, Ruth, for your comments. Probably the answer to your big questions you are putting on the table is access to justice. International arbitration, it's very expensive. And how do you want a private person or a company claiming against state? Probably the answer is third-party funding, but anyhow, that's something we are to discuss. Let's move to Dana McGrath. She is an independent arbitrator, and she will have the floor now. Thank you.
Thank you, and thank you for having me here today. I will be wearing the commercial arbitrator hat for this portion of our panel, although I suspect there are a number of questions that will be put to Ruth and my colleagues at the question and answer period. But with respect to commercial arbitration, and specifically commercial international arbitration, it lacks the transparency that investor state arbitration has. And so there's very little known about the extent to which third-party funding may or may not be used to finance claims in international arbitration. And many companies choose international arbitration as their preferred dispute resolution proceeding because of the confidentiality that can be afforded if steps are taken to ensure the confidentiality of the arbitration. And that's one myth I want to dispel, that just because you are in commercial arbitration, that does not deem the arbitration de facto confidential. There are some rules in various arbitral institutions that extend confidentiality to certain players or stakeholders in the proceeding, but in order to actually ensure confidentiality of an international arbitration, it's really incumbent on the parties and counsel to propose an agreeable confidentiality agreement. But I think for our purposes, let's assume that we're talking about private commercial international arbitration that is covered by a confidentiality agreement. And so where does third-party funding come in? And that, I think, that's had a sort of a trajectory of uncertainty for about 5 or so years, where individually separate arbitral institutions would come out with either guidance notes or an amended rule with respect to the disclosure of third-party funding. And for the most part, in international arbitration, it has been focused on conflicts and disclosure so as to allow an avoidance of conflicts from the beginning of the proceeding. Although there's always in every arbitration an ongoing obligation to disclose something that could be a basis for a conflict. So in a commercial arbitration, increasingly the rules or guidance notes essentially require that if a party has third-party funding in the arbitration, and it's typically the claimant or claimants, that they disclose the fact of funding and the identity of the funder, so as to allow any disclosures by the arbitral tribunal that might impact the arbitrator's independence and impartiality. And I say this with you all knowing that I have a history previously of working with a third-party funder. So I, in particular, want those disclosures. Even if I am approached for potential arbitration, you know, I try to make clear that I was with Omni Bridgeway. And so, you know, that's if that's an issue, I don't want to hear about it. Like, let's end this discussion. And I've not been with Omni Bridgeway now for some years, but I think it's telling that the concern and perhaps inflated concern about the conflicts that could be created between arbitrators based on third-party funding perhaps it's overblown, but nonetheless, I think it's important that you disclose to protect the award. And as an arbitrator, you know, that's our first and foremost duty, is to, you know, ensure fairness and due process to the parties, but also to render an enforceable award. And so disclosure and avoidance of conflicts are critical to that. You know, I've yet to hear a true story of a disclosure has to do with a familial relationship with someone with a funder or something else. I mean, I'm sure that could be the case, and I've just not heard about it, again, because commercial arbitration doesn't get as much visibility and isn't as discussed because of the confidentiality. So I think that the key thing with respect to commercial arbitration is to avoid any appearance of bias or impartiality, and disclosure achieves that. Beyond that, I really don't see, and I haven't experienced an ask by respondents about the funding agreement. That's not to say that there aren't council-to-council discussions that the tribunal is not aware of. But in my experience, it's been almost a pro forma, like disclosures are made at the beginning. Everyone's reminded of their ongoing disclosure obligations, and it's left at that. But I do think that it's worth dispelling, and maybe this is, you know, a broad statement, but dispelling the myth that, you know, the fact of funding somehow puts a label of some sort of merit or strength on the case. I mean, many arbitrations have multiple claims, just like in litigations in court. It's not necessarily one claim. There could be, you know, 8 different claims. And there's no insight as to what the funder has assessed, analyzed, or whatnot, or why they have invested in either a single funded case or if it's a portfolio, and query whether even a party that case is part of a portfolio would know. I defer to my colleagues who are still very active in the funding space to address that, but there may be, you know, in the eyes of a claimant, nothing to disclose if they are not aware that their case is part of a portfolio or not. I don't think that would create a conflict. I just think that there's still, you know, this law is still developing, the practices are still developing. Arbitration finance is becoming increasingly sophisticated. And for the purposes of arbitral tribunals, I think it's important simply to avoid conflicts. And I, for one, think that there's really no conclusions to be drawn regarding the strength of a claim or claims, simply because of the fact of funding. And I think that it's that myth, so to speak, that is a source of the sort of the pressure or the incentive of parties who learn that a claimant or a party is funded to learn more about the funding terms, because they think that they're going to sort of somehow get, you know, underneath the strategy of the case. But again, is from my historic dated experience in funding, the funders are not running the case. It's counsel who are running the case. And so it's really not, in the funding agreement or the details relating to the decision to be funded or whatever the portfolio backdrop may be, that's not really a meaningful source of information for defendants in a case, I don't believe. There could be some aspects that, as it becomes more and more sophisticated, could be of interest to the defendants, but I think it's far outweighed by the burden of asking for all sorts of information that is, I think, subject to a number of privileges. And in international arbitration, you're dealing with very different privileges from around the world. It's not just what we understand here in the United States. And so, I await the day when this issue comes to me as an arbitrator and I'm being asked to decide, the extent to which, if any, aspects of funding would be required to be disclosed. But I do think that I was, before being an arbitrator and in third-party funding, I did arbitration counsel work for 2 decades. So I'm not naive to the idea of strategic advantage and wanting information for strategic purposes. I just think that it's a little bit overblown how much really is to be gained by drilling down on the third-party funding. And it sort of becomes a sideshow that creates a very strange dynamic amongst counsel and the tribunal. It's different from when you're asked to decide issues, pure issues of attorney-client privilege or attorney work product with respect to, communications that dealt with the underlying transaction that led to the dispute. So I'll stop there because I know there must be a number of questions and we're being kept on time. So thank you.
Thank you very much. So I think now is the appropriate moment for questions and answers from the audience. Please. Who takes the first question? Please.
Erica Levin, hi, thank you. Erica Levin from Fox Rothschild. First of all, I want to commend you all on all of your presentations. They were excellent. I think you all gave us a lot of really incredible food for thought. I want to come back to Jeff just in terms of questions. I think that a lot of the points that you were raising in terms of arbitration, they run throughout, and the accessibility to information, especially within commercial arbitration. Have you seen anything in terms of the decisions enforcing recovery with respect to the funding in the US? I know because of UK, we have Esther Northcott, right? 2016 decision. There's precedent out there, but I was just curious because you had your hands on a lot of the details, if you've seen anything with respect to the US or not. But it's just an interesting phenomenon. And I remember being in the funding space at that time. And when Esther was decided, that was pretty revolutionary, right? We were like, what? It was incredible. So I'm just curious if you have any information.
Thank you. Yeah, I'm happy to take a first stab at that. I mean, it's strange, but there are only 2 decisions, and we only know about these 2 ICC awards because they were challenged under Section 67 and 68 of the English Arbitration Act before the UK courts. Otherwise, we wouldn't know about these decisions. So that tells me a couple of things. First of all, there are more of these ICC awards out there, well more than 2, where arbitrators, sole or panel, have awarded the costs of funding. Keep in mind, in commercial arbitrations, those costs of funding are much more modest than they are investor state. So it's not just 2, I think it's probably double digits. I'm not aware of any cases of yet before the US courts, but I think it's just a matter of time, because increasingly we're seeing dissatisfied respondents challenging awards, be they in the investor state context, challenging through an ad hoc committee to ICSID, or at the seat of an arbitration in a commercial arbitration or a non-ICSID arbitration. So I think it's just a question of time.
And to that point too, we need a lot more arbitration of awards to be disputed the actual agreements. That's what and I'm sure Ruth and Dana, I don't know, Victoria's seeing it. Sorry, I was just saying, we're seeing now that funding has been around a long time, we are starting to see, because most funding agreements are subject to arbitration. And so I know I sit as an arbitrator, we are sitting and as counsel, and we're seeing more and more actual arbitrations over the funding agreements. Hopefully not too many, but we are seeing them. So I think that that's another aspect too. So, and I don't know if anyone wants to comment on that. But thank you.
Hi, I'm Chad Schmerler for Pretium. And this one is for Ruth, because I found what you said really fascinating about ICSID and sovereign debt. I'm trying to understand exactly where you're going with this, because for me, you look at the history of sovereign debt, and you're a lot better off having litigation and disputes than blockading ports of countries that don't pay. And so the evolution of it has been from war to collective action clauses, Peru, Mexico. So there's a few hundred years of this that bring us to the current point, and sovereigns have always resisted in one form or another, and most of them don't get sued. And sometimes you can make an awful lot of money investing in sovereign debt. Witness the case in Greece. So what's and this I just didn't really follow, so forgive me. What's the thesis here, that sovereigns just don't ever want to get sued, and this is causing a problem in ICSID with funding, or is it far more than that and more nuanced?
I think it's that it's about the money that they have to pay. They're not small awards. They're billions. And it's not, and it's also what's going on is actually that sovereigns don't want to pay, and there are sovereigns that cannot pay. And now there are more countries which can pay, but do not pay. So this is actually happening more and more, that awards are not getting paid. And when I was working on the funding side, I found it disturbing how, from an investor perspective, how long and how unpredictable, and how there's just no data. Actually, you're really shooting in the dark. You have no idea whether you're going to get paid. I don't care what they say about the sovereign credit rating of, it's actually very improbable and arbitrary how you get paid. So from the investor perspective, I found that daunting. And then I was at Tenor, and Tenor is still involved in the ongoing Crystal X enforcement proceeding. And of course, that was very frustrating because the US sanctions program froze Citgo, hived off Citgo from creditors because of a national security concern. And I remember thinking, this is really wild that the US is intervening. You know, we're a Canadian creditor. The company was a Canadian creditor. But if you read the US pleadings and just take them at their word, what it says is that this award is not your problem, Venezuela, it's our problem. It's if we allow Citgo to go, it's a problem we have with Russia and Iran and Cuba, and we're gonna, and the sovereign debt's gonna flow to Peru. So that's, Citgo is basically the Treasury Department of Venezuela now, and they wanted to support Guaido. So it's a very convoluted. Are you following? Tell me if you're not, just stop me because I can. But the point is,
I'd totally be lying if I said yes.
To me then, I thought, well, why doesn't the US pay for these awards then? If it's going to freeze these assets. I mean, the UN intervened. So I said there's no international bankruptcy regime, and that's true for governments, but every once in a while, there is an intervention by the UN, such as in 2003 for Iraq, where it froze Iraq's assets to help Iraq reconstruct itself. Okay, so that's an example. And what I'm saying is that this has to happen. We have to reconstruct. We're going to have to I can't even speak, restructure sovereign debt now. It's happening now. And these awards should be part of that restructuring, but it should be done in advance. And it would be great for investors too. Can you imagine if you knew that you were guaranteed a payment by the IBRD on an ICSID award over time, what the IRR on that investment would be compared to what it is now? It's so the fact that this isn't done, I think, was just because the drafters of the ICSID convention forgot about the money. They didn't think about money. They were lawyers. They didn't think about the money. They were brilliant international lawyers. And they didn't have the perspective of the 90s sovereign debt litigation. They didn't have the perspective of the Asian debt crisis. So it was just out of time, and it's an extreme success. But this money, I think, has to be solved because this is the whole thing. When states talk about these awards will have a chilling effect on our ability to regulate. And by the way, now this is about climate change. I'm not just doing this to be sort of au courant. This is actually what they're saying at UNCITRAL has performed, that now investment arbitration is incompatible with climate change. Now, that's not, I don't think, true. It's the money that they can't make this work. and the wealthier countries are saying, jump this way, jump that way, do this. I mean, it really is, it's kind of obscene what's happening. So I think we've reached a point now, we have to solve this and collectively finance it. So they can insure themselves. Why can't sovereigns insure collectively this award debt? They absolutely can. If the WTO, which I don't know what they do with the 200 million they collect right now, if they can collect that, how much do you think is paid out a year, Jeffrey, who has more information than I do? A year on ICSID awards. ICSID has no idea. They don't have an interest in this number. How much would you speculate?
Well,
is paid
probably-
a year?
Probably, Ruth, I think we should listen
Yes.
to other people on the panel. I think Jeff, probably, I would like to your intervention if there is any connection between sovereign debt and investment arbitration financing.
I would say just one thing, there is no data. ICSID does not, as you rightly point out, ICSID does not track payment of awards. It's all anecdotal. It's what's reported. So you cobble together, and we've cobbled together everything that's available in the public domain and plus what we have in-house, but it's just, there's so many holes in the data that you really can't make any meaningful conclusion.
So now I think I understand. You're, and I mean this with all sincerity, you're suggesting that ICSID needs to be revised because the sovereign debt regime, besides the efforts over decades and centuries to create a bankruptcy regime, rejected, but
Bankruptcy.
that's what it's, some sort of an insolvency.
Bankruptcy regime.
Oh, I know. What I'm saying is you're suggesting that this regime, ICSID, needs to address something that's been
Yes.
failed through Treasury, IMF, John Taylor, all of that over the years. This should be revisited now, and that's
Yes.
got it.
Help
Okay.
plan for Argentina, but.
But
so we're not
something,
gonna speak-
something
Got
is
it.
very clear. Something is very clear. Nowadays, people are interested in financing claims against Venezuela. Why is that?
So if I can jump in here, Ruth, I think though, there's a logical step or premise to the story that you told, which is that there's a problem with the sovereign being held liable in the first place. Presumably, they lost an exit arbitration because they violated a bid arbitration, a bid commitment that they have. And so if they were wrong, they need to pay the foreign investor. And the fact that there's then a global chase on how you structure that debt, that may be a story about sovereign debt, but it's not a story about the fact that there's, by definition, a wrongful sovereign in the sense that a tribunal found them to violate a bid. And so the fact that people are investing in that arbitration that turns out to be meritorious, I think those are two separate things.
We have a question here, yes.
Thank you. This is not a legal question, but like more of an economics question. When we talk about third-party financing, how does it impact societal innovation? Because there are certain parties, which they call patent trolls, who buy rights to second and third degree patents, non-quality patents, and they go to court and ask for injunctions, arbitration, and everything, and that in totality hurts society because you're stopping others from innovating. So how do you manage that, not only in the United States, but other countries? Have you seen that cost-benefit analysis or? Thank you.
I can comment from the perspective of commercial international arbitration. I mean, it's a matter of incentives. Let me give you one example. Usually in the United States, when you have shareholder disputes about IP rights or something like that, maybe you set up a class action. In the case of Brazil, for example, they have a specific provision, two specific provisions who are the incentive to finance this type of disputes. Which are those provisions? First, Article 246 of the corporate Brazilian law established that in shareholder disputes among minority shareholders and majority shareholders, if you are able to compensate the company, you are entitled to a 5% premium, whatever the amount is. Could be billions, could be millions, or could be just 100,000 reais. So it's important when you establish a strategy in international commercial arbitration to interconnect local regulations, because sometimes the disputes are subject to Brazilian law. Then the incentive to answer your question will be, okay, is there any type of provision that establishes a specific compensation? And the second regulation, which is, I guess, the magnificent work of the lawyers' lobby, is that in the Brazilian constitution, there is a provision that lawyers are entitled to 20% of any compensation. And sometimes they have tried to apply also to international arbitration, which could be very big. And that's an opportunity for some funders, because some funders negotiate with the lawyers. Okay, I'm going to put the money, but I want a piece of that 20%. That could be substantial. So my comment to your question is, depends sometimes in the interconnection of local provisions in the local regulations and what is established in the terms of reference or the rules of the arbitration.
Please.
So feel free to correct me if I'm wrong, but as I know, investment arbitration has been criticized for its tendency to be like more pro-investor, and for tribunals have also been, a so-called jurisprudence have also been criticized for its tendency to protect investors. But do you think the approach to protecting the investor as a weaker party within proceedings should be changed in proceedings where this investor is being funded? So should parties that are being funded be treated different in terms of proceedings by the tribunal? Do you have any comments of that?
Jeffrey.
Yeah, I'm happy to start on that. First of all, and then this goes back to the misinformation point. I mean, investors don't win more than sovereigns. It's actually pretty even. I mean, it varies every year. I think ICSID just came out with the latest stats report earlier this week, and that's, it gets bandied about in UNCITRAL Working Group 3 that investors are winning more than 6. It's just wrong. I mean, we have spreadsheets, we can show all the dispositions. I mean, yes, cases get settled, cases are discontinued, but it's just not accurate that investors win more. And as to your second question, should the fact of funding have a role in the adjudication of the dispute by the arbitral tribunal? No. And tribunals have shown that that's not, I mean, now they have more, there's more transparency, so they're aware of the fact of funding with increased frequency, but the cases are judged on the merits. Is there a treaty breach? Was there causation? Was there damages? Is there jurisdiction? The fact of funding is neither here nor there. It's really, going back to what Bernardo said, an access to justice question. In many of these cases, but for funding, the aggrieved investor could not have brought a suit. And with funding, they can.
Well, you see, many states were complaining some years ago, saying that the investment arbitration was pro-investor. But really, the statistics doesn't say that. And the ICSID really put on the table the statistics, and that was not the case. Probably the question in investment arbitration, it's more a political issue on the international level. And that's probably the reason why it's so criticized and why third-party funding is very criticized in investment arbitration. Why? Because in many cases, the only way to access to international arbitration justice is through third-party funding. And the states know that. And that's the reason why it was so critical issue when modifying the ICSID rules. But anyhow, that's a question being discussed. I have a question for Dana. Dana, do you think as a commercial arbitrator, do you feel somehow in a bad situation when you realize that there is a third-party funding in the case?
No, that wouldn't bother me. I haven't yet had a case where there's been a disclosure of third-party funding. And I always ask for it. So, but it would not affect my view of the case. And just on sort of a side issue to follow on to the point with respect to investor-state arbitration, and the fact that it is far more balanced in terms of the outcome for claimants and respondent states. It's not a majority of the claimant investors that win all of these cases. And you have to imagine that this investor may have nothing when its property is expropriated, right? That was its sole asset, so it needs funding to be able to pursue its claim. But it's early days when a claimant approaches a funder, you know, it's before there's even, usually it's before the arbitration has even begun. So as much as can be understood by the funder and the claimant with respect to what happened, and there's a lot that happens on the ground in countries around the world that you don't find out about ever, but you maybe find out as the arbitration unfolds. It's a very complex factual matrix that you know, is involved in every investor state arbitration. And so it's a challenging field for funders, quite frankly. Not only the enforcement side at the end of it, if the claimant wins, but even just, you know, to get a full grasp to the extent you can in the early days of what the dispute's really going to turn on with respect to an expropriation or another, you know, treaty violation against a claimant. There's real reasons why it's not, you know, a landslide win for the claimants out there.
Thank you. There is a question over there.
There's a question. Oh, this one.
Okay.
Hi, I wanted to ask, to what extent do you think that third-party funding can raise the quality of legal services, not just in terms of the quality of the lawyers, but how effectively they're deployed? So besides obvious cases where somebody just doesn't have access at all because they can't even afford to start the case, or they can only afford, you know, low-end legal advice. But assuming a reasonably sophisticated party that can at least somewhat fund itself, how much does having a third party kind of benefit either the quality of the deployment of the lawyers? Because I was thinking on the defendant side, for example, with homeowners insurance, the typical homeowner, you know, doesn't really know how to hire a lawyer or handle a lawyer, understand what they're doing if somebody has a claim against them for an accident or a slip and fall. So the insurance company is a repeat player and has lawyers it works with in different subject matter, different areas. On the plaintiff side, so how much does that benefit having a third-party funder?
It is very clear that a funder, before going into putting the money, makes a risk assessment. And in the risk assessment, he makes very probably one of the very first points is the quality of the lawyers who are involved. Because at the end, the result of the proceedings depends very much who is the master of the proceedings. So my impression is that the research made by the funders makes quality of the lawyers involved much more important. Please.
Hi. So I'm curious, there's been discussion of some different organizations or tribunals' rules around third-party funding, and I'm wondering what you all think the optimal form of a rule on disclosure would be. So I would think that there's something of a spectrum from, for example, the prime finance rules in 2022, which are quite broad. The text of Article 5 is something like requires disclosure of the identity of any third party with a significant interest in the outcome of the dispute, including but not limited to third persons funding any claim or defense and the nature of their interest. And then the ICSID rule is, of course, very focused on, you know, direct or indirect receipt of funds or remuneration for a claim. I'm wondering what you think the kind of appropriate scope of such a rule would be. And one of the neat things about international arbitration is with so many different tribunals and organizations promulgating rules, it's kind of this procedural sandbox where there's, I think, a lot of different good ideas on how to do this. So I'm wondering if there are good examples you have.
Jeff, do you want to answer?
I'm happy to. I mean, the answer, at least in the investor state context, is Rule 14, which ICSID spent. I mean, it was part of a larger amendment process, but they spent 5 to 6 years on this. Sorry?
Someone's laughing.
No, no.
I don't know that.
Okay, oh, yeah, it was a long process. We submitted a working paper and then it was several years before. Yeah, I mean, but I think, look, I mean, to the extent there needs to be disclosure and it was determined that there needs to be to avoid conflicts of interest and to avoid challenges post-arbitration to awards. There is this fact of funding kind of disclosure rule, and it's not just ICSID. The ICC introduced it about a year before ICSID, and it's in most commercial rules. It just happens that ICSID is the leading institution for investor state disputes, administering more than 70%. And the ICC is the leading global institution for, to my mind, international commercial arbitration. And both of those institutions have very similar rules now that provide just for disclosure of the fact of funding to avoid an unfortunate outcome where you have a conflict with an arbitrator. So as to your question, I would say Rule 14 or the equivalent in the new ICC rules.
It's very, well, last question. Yes, please.
I just wanted to follow up on disclosure real quick. It's not clear to me why the parties themselves cannot designate how much disclosure they want in the arbitration context. Presumably, the reason you're going to arbitration is there's an agreement between the two sides to go to arbitration. Why can't you write in your agreement that if any party in the arbitration has third-party funding, they must disclose this, this, that, and this to the other side?
There's a legitimacy problem. So the difference in international arbitration is that you have awards that are rendered by private arbitrators invested with their power through the contract that the parties have agreed to. But behind that is the governmental court system that's set up for the purpose of enforcing those awards. And so the challenge is that when the award creditor takes that award to try to get it enforced in a court system, that court is going to be concerned about legitimacy if there were potential conflicts of interest that existed and were not addressed that could have potentially tainted the award through allegations of bias or other impartial and independent activities by arbitrators. And so that's the reason why the parties can't contract around the conflict of interest requirements. They come from the arbitral institutions themselves.
When they require more disclosure, though.
Yes, they could always require more. Well, there are, the problem is when you're entering into the contract, you don't know which side you're going to be on when the dispute arises, right? So it'd be, you could think of rules that would be beneficial for a claimant, and then you could think of provisions that would be beneficial for a respondent, but you don't know which one you're going to be, you know, in advance. And so what rules would you negotiate for?
That almost there's credence to whatever the agreement says, because if you're behind the veil of ignorance, no one wants disclosure.
And that leads me to think that maybe that is the fairest rule. The parties are, you know, exhibiting that by not.
The courts won't allow that because you have a process. I mean, even in US court, we actually have statutes that say you can challenge an award on the basis of bias, the Federal Arbitration Act. And so that allegation of bias would come from simply just the non-disclosure of the conflict. Doesn't actually mean that they actually think the arbitrator is mentally biased. It could just be because they didn't disclose, we're going to make this assumption, and therefore we challenge the award. And the courts would say, well, that's what the statute says. So therefore, we can't rely on the contract, even if the parties tried to create a rule that would be beneficial to in a balanced way to claimants and respondents, but I think would be tough.
There have been
On
other
behalf
contexts.
of
Sorry.
the panel,
Yeah.
I would like to ask Victoria to make some concluding remarks, thanking everybody for your patience being with us today.
Thank you, Bernardo. And thank you everyone for this lively discussion. And thank you to our panelists who prepared such very detailed and thought-provoking remarks. You know, I'll just, in the interest of time, I'll just be very brief and I'll say, you know, one thing that this discussion has really highlighted is the asymmetry in the dynamics in international arbitration. There's a divide between commercial and investor state arbitration because of the rigidity of the roles in investor state arbitration. You have investors who are always claimants. You have states who are always respondents. There are a few exceptions in modern times, but the system was set up that way. And the funding often flows one way, although I know some funders have funded on the respondent or defense side. For the most part, the funding flows from the claim side. In commercial arbitration, on the other hand, you can have more balance because you can have counterclaims, you can have funding on both sides. And so the investor state context raises a whole host of structural problems. As Ruth said, the third party funding is sort of shedding a spotlight on problems in the system that were already existing. And so I think it's important that we continue to try to fix those problems as best we can through our international organizations. So thank you, and thanks for
Thank
working
you.
with me on this,
Thank you
Bernardo.
to
Thanks to all
everyone.
panelists.
Thank you very much.
Thank you.